is assumed that criminalization of marital rape will destroy the institution of marriage in India. But people usually tend to forget that rape by the husband is what destroys the institution of marriage in India. Blessing days, greetings to everyone. This is Jahnavi and I'm the presenting on analysis of marital rape in India. Even today, the marital status of women determines her victimization. Protection of Women from the Domestic Violence Act recognizes marital rape, but not only provides for it just provides for civil remedies and not criminal remedies. Marital rape is in gross violation of various articles that are provided in our constitution, namely Article 13, 14, 15, 19, and 21. It is also in violation of law, international conventions and treaties, and also not in accordance with the DPSPs. Moving on, life is precious in itself. It is worth living because of the freedom which enables each individual to live as it should be lived. The best decision on how life should be lived are entrusted to the individuals. Taking away this choice just on the basis of marriage or misuse of their rights is just not right. The UN Population Fund found that more than two-thirds of married women in India between the ages of 15 and 49 have been beaten up, raped, or forced to provide sex. The UN Committee on Elimination of Discrimination Against Women recommended India to address these injustices. This was also reinforced in March 2016 by the UN Development Programme Chief Helen Clark. As noticeable efforts had been made in reassuring married women that they have a say and right over these bodies, it is high time that India take few steps towards the same. Failure of the parliament to criminalize marital rape. On 22/12/2012, the central government appointed a judicial committee headed by the retired Chief Justice of India, Justice J.S. Verma, to provide amendments in criminal law to check offences against women. While in its report dated 23/1/2013, the committee made several recommendations, including the striking down of Exception 2 to the Section 375 of the Indian Penal Code, and that the law should not consider the relationship, marital or other, between the accused and the victim as a defense. The committee further recommended that relationship between the accused and the victim should not be taken as a mitigating factor for lower sentence of rape. Moving on to Protection of Women from Domestic Violence Act 2005. In 2005, the Protection of Women from Domestic Violence Act 2005 was passed, which considers marital rape as a type of local violence. Under this act, a married lady can go to the court and get legal partition from a husband for marital rape. The act offers civil remedies instead of criminal. It provides protection against domestic violence and sexual provisions. It is quite unsatisfactory that violence against women should be seen as a civil wrong rather than criminal offense. If marital rape is made into a criminal wrong, then it would act like a deterrent and prevent future crimes. Marital rape is not unreasonable, as when a lady's body is raped, it's her affection as well as the trust is damaged in such a way, throwing her into a position of instability and dread. Her human rights are relinquished as the holy place of marriage. However, the laws secure the interests of casualties of marital rape are lacking and deficient, and the means taken are definitely unacceptable. Moving on to the statistics regarding marital rape. In 2013, the National Crime Records Bureau reported over 118,000 domestic violence cases, which made up a third of all the crimes against women, for ahead of molestation and rape. The murder of reported domestic violence case also shot up from a mere 50,703 in 2003. In 2006, it was estimated that marital rape is an offense punished under the criminal law in at least 100 countries, and India is definitely not one of them. 18 out of every 100 men across India believe that the husband has the right to get angry and reprimand his wife if she refuses to have a sexual intercourse with her husband. The plea read according to the bar and bench. At the state level, 43% of men in Andhra Pradesh, 42.6% in Telangana, 25.5% in Mizoram, 21.7% in Jammu and Kashmir, 20.3% in West Bengal, and 19.9% in Karnataka felt the same way. 5% of the married women from 15 to 49 years of age report forced intercourse by the husband as per NHFS data. 2.5% claim that their husbands forced them to perform any other sexual act which they didn't want to do. In 2005, 6, 7, 8, 9 cases were recorded of women murdered by their husbands or their husbands' families. 56% of the Indian women believed occasional wife beating to be justified. At the state level, 11.4% of the women in Bihar, 10.6% in Manipur, etc., they were physically forced by husbands to have sexual intercourse even when they did not want to, as per the NHFS data. Moving on, violation of Part 3 of the Constitution of India. So, marital rape violates Article 13, 14, 15, 19, and 21. So, starting with Article 13 of the Constitution of India, Exception 2 of Section 375 was drafted on the basis of Victorian patriarchies of 1860, who later in time changed these laws but has not been removed since independence in India. Though through Article 13 Clause 1, the laws existing as 1950 are found to be inconsistent with the inalienable fundamental rights and should be declared void. According to the Peerless General Finances of the Reserve Bank of India, it is the duty of the country to zealously and actively protect and enforce fundamental rights, and a law found to be encroaching upon a fundamental right of a citizen must be mandatorily be struck down and declared as unconstitutional and should be declared following the doctrine of severability. Under Article 13, Clause 1 of the Constitution, triple talaq was also struck down at one go as being opposed to fundamental rights under Article 14, 15, 19, and 21 of the Constitution of India. So, starting with Article 14, Article 14 comprises of two phases: equality before law and equal protection law, which was given in the case of Kedarnath Bajori of the state of West Bengal. It is a essence of democracy and accordingly a basic feature of the constitution. The concept of equality is a dynamic concept which has many dimensions. Although the constitution guarantees equality to all, Indian criminal law discriminates against female victims who have been raped by their own husbands. Indian laws enacted at that time were very deeply influenced by English laws and Victorian norms. The marital rape exception to the IPC's definition of rape was drafted on the basis of Victorian patriarchal norms that did not recognize men and women as equals, did not allow married women to own property, and merge the identities of husband and wife under the doctrine of coverture. But times have changed. Indian law now affords women and wives separately and independent legal identities, and much jurisprudence in the modern era is explicitly concerned with the protection of women. This concern is evident in the plethora of statutes intending to protect women from violence and harassment that has been passed since the turn of century, including the protection of women from the domestic violence and sexual harassment of women at the workplace, Prevention, Prohibition, Redressal Act. Exception 2 of Section 375 of IPC classifies rape victim into three categories, namely married, unmarried, and married but separated. Article 14 allows reasonable classification for the purpose of legislation uh, and legislation which forbids class legislation. The test of reasonable classification was laid down by the Supreme Court in the case law Bugdan Chaudhary v. State of Bihar, which provided that the classification proposed in the legislation must be founded on intelligible differential and there must be close nexus between the classification and the object sought. Unmarried women facing sexual assault are being protected under Section 375 and 376 of the Indian Penal Code and did not afforded the full potential of the present law. A married woman raped by her husband cannot seek justice as this is supposed to be legal under exception to section 375. Uh, so moving on to the test of intelligible differentia. Firstly, there is no intelligible differentia. The expression intelligible differentia means difference capable being of understood and should be reasonable and not arbitrary. It is submitted that married and unmarried women are neither separate class or not separate communities. They belong to the same class as to the same community, and thus there is no ground for differentiating between them in terms of punishing their predators. Any differentiation between the same would be unreasonable and arbitrary, and thus proving my point there is no intelligible difference in the present case. Moving on to the second clause, there is no rational nexus. It is evident that there exists neither rational object nor rational nexus in discriminating married women against unmarried women with respect to the sexual assault. The test of intelligible differential should have a rational relation with the object of the legislation. There is no reason why marital rape is legal and any is illegal, and it is mandatory that every act must have a reason, or it becomes arbitrary per se in the absence of a reason. It is not only manifestly unreasonable and arbitrary, but contains the quality of unfairness and exhibits naked despotism and is clearly violative of Article 14 and fails to protect women's physical integrity. Thus, the provision must be struck down. Moving on to the test of manifest arbitrariness, in case of Shaira Banu versus Union of India, this is our Nariman. This particular test to determine the constitutionality of triple talaq. It was observed that manifest arbitrariness, therefore, must be something done by the legislature capriciously, irrationally, and or without adequate determining principle. Also, when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. We are therefore of the view that arbitrariness in the sense of manifest arbitrariness, as pointed out by us above, would apply to negate legislation as well as under Article 14. The impugned provision are manifestly opposed to the legitimate objects of the criminal law and the fundamental rights of women to bodily integrity and sexual autonomy, hence her right to personal liberty. Moving on to Article 15, the exception of Section 375 assumes non-retractable consent of women to sexual intercourse into marriage. This assumption reinforces various gender stereotypes leading to subordination of women and hence violative of Article 15. In the case law, Nalsa Association of India made it clear that categories in Article 15 are not exhaustive and include gender identity, for instance. As such, marital status of women may be read into sex and may be recognized as a ground for sexual and gender discrimination. This particular article was formed with the purpose to eliminate all kinds of discrimination, including gender discrimination. In the present case, there is clear discrimination on the basis of marital status and thus should definitely be removed. Moving on to Article 19 of the Constitution. The impugned provisions of law do not recognize the right of a married woman to say no to sexual intercourse with a husband. As a corollary to the impugned provisions, also take away a married woman's ability to say yes to sexual intercourse, both aspects which from the exception to of Section 375 of IPC proves being contrary to Article 19, Clause 1, Subclause A. The Supreme Court in Nalsa Association of India stated that Article 19, Subsection 1, Clause A of the Constitution states that all citizens shall have the right to freedom of speech and expression, which which includes one's right to expression of self-identified gender. Self-identified gender can be expressed through dress, words, action, or behavior, or any other form. No restriction can be placed on one's personal appearance or choice of dressing, given to be restrictions contained in Article 19, Clause 2 of the Constitution. Given that the marital rape exception trammels a women's sexual behavior as well as her choice, and thus cannot be justified under any heads of Article 19, Clause 2. On this ground alone, the provision is liable to be struck down. Moving on to violation of Article 21, life within the meaning of Article 21 is not confined to integrity of physical body. The right comprehends one's being in fullest sense, starting from violation of right to life and personal liberty. The case of Maneka Gandhi versus Union of India, it has become the source of all forms of aim for protection of life and liberty, which also give the meaning of life and thus can be appropriately summed up the words of Phil J. celebrated judgment of Mun versus Illinois, where he held that life means something more than mere animal existence, which was also affirmed in the Supreme Court in the case of Bandhua Mukti Mochi versus Union of India. Moving on to like, moving on to a right to live with human dignity, it was provided in Prem Shankar Shukla's Delhi administration that even handcuffing the trial accused of non-bailable offense punishable with more than 3 years was found violative of Article 14, 19, 21. The Supreme Court held in a category of cases that offences of rape, abuse, the right to life, and the right to live with human dignity of a victim of the crime of rape. One such example is the chairman Railway versus Chandrima Das, Bodhisattva Gautam versus Subhadra Chakraborty, where they give right to life with human dignity. Moving on to right to make choice, Suchita Shrivastava versus Chandrika administration, the Supreme Court equated the right to make choices related to sexual activity with the right to personal liberty, privacy, dignity, and bodily integrity under Article 21. A right to abstain from sexual activity in Justice case Puttaswamy versus Union of India, the Supreme Court recognized the right to privacy as fundamental right of all citizen and held like right to privacy includes decisional privacy reflected by an ability to make intimate decisions primarily consist of one's sexual or procreative nature and decisions in respect of intimate relations, which is definitely being violated in the present case. Right to sexual privacy, which is also in the case Puttaswamy Union of India, corrects in the state of UP, Govind is the state of Madhya Pradesh, Neeram Mathur's life is being violated. Moving on to right bodily self-determination, the idea of right of self-assurance depends on the conviction that individual is a definitive chief in matters intently connected with her or body or prosperity for the more private the decisions, the more vigorous reasons likely. All the adults have a right to sexual autonomy and bodily integrity. That without the right to not to be raped, married women are legally reduced to sexual and reproductive subjects as such. That the inability to say no to sexual intercourse, whether it is recreational or procreational, also takes away the right married women to say yes. Moving on to right to good health. It is recognized as a part of Article 21 in the case of CESE Limited versus Subhash Chandra, 1992 1 SSC 441, Regional Director ESI Corporation, Francis de Costa, and thus uh, the marital rape is definitely violative of Article 21. Moving on to violation of directive principles of state policy, uh, in Article 51A of the Constitution states entirely to renounce practices derogatory to the dignity of women. It is clear that the impugned section is violative of this directive, and marital women should not be subject to arbitrary and unilateral whims of husbands as they are subject to in the present case. There is also violation of international conventions and treaties. Article 2, Clause 1 of the International Covenant on Civil and Political Rights provides for equal rights for men and women. Article 3 imposes a duty on the state to ensure equal right of men and women to enjoyment of civil and political rights. Article 7 provides for protection against inhuman degradation treatment, while Article 9 recognizes the right to liberty and security of a person. Moving on to Convention of on Elimination of Discrimination Against Women, Article 2 provides that the state parties to condemn discrimination against women in all the forms. UN Women Rights its reported in Progress of World's Women in Pursuit of Justice showed that India, amongst the few nations that continue justify violence by a man upon his wife. And Universal Declaration of Human Rights, Article 2 prohibits discrimination on the basis of sex and or religion. Further, Article 1 of International Covenant of Economic, Social and Cultural Rights defines discrimination as discrimination against women on the basis of sex. Article 2 of the Convention mandates that all the state parties would take all steps to eliminate discrimination against women in India in all the forms. Moving on, Article 51C of the Indian Constitution provides to foster respect for international law, treaty, and obligation. The courts are under an obligation to give due regard to international conventions and norms for constructing domestic laws more so, and there is no inconsistency between them, and there is void in domestic law. The Honorable Court in also Union of India stated that it was the duty of the state to comply with the obligations made under the international conventions. Moving on, to arguments against this decriminalization of marital rape. So, firstly, the most common is that it is against the culture. The government is arguing that since the majority of people in India are illiterate, uneducated, poor, conservative, and religious, unlike in America or all the other modern countries, they believe that the husband cannot rape his wife because a good Indian wife will dutifully consent to her husband always and forever. This, the government submits, is a unique obstacle India faces in criminalizing marital rape, the admission of which it acknowledges that lakhs of men are violating their rights, sexual consent on daily basis based on their mindset, and that's why they're doing is in fact the crime of rape. Then the government argues that if such circumstances, the criminalization of marital rape, a majority of marriages will just fall apart because women will stand up for their rights, who will then become criminals in the eyes of law and avail the legal recourse. They should seek justice and protection. But if it is actually the fear of marriages falling apart that is stopping the government from criminalizing marital rape, then in a way it acknowledges that the legal recourse and protection women will want to end sexual violence they face on daily basis within their marriages. At which point it becomes important to ask, by placing so much value on marriages and family and pushing for status quo, whose side is government protecting? The husband's raping or the wife's being raped? None other than the Supreme Court agrees that criminalization of marital rape does not threaten the marriage in any way in independent thought. This is the Union of India. Moving on, once married, women's personal consent is implied. Even as British moved in England, Wales in 1991, Lord Pitt communicated on behalf of the court that modern marriage is partnership of equals, and wife is no longer considered to be a chattel of a husband. Indian law, even today, concerning the marital rape, has the same point of view that others had in 1991. As far as this argument is concerned, it is true that the wife impliedly consents to sexual intercourse with her husband after marriage, but the expression of love through sexual intimacy is not the same as forced sex. On the other hand, it strikes at the very foundation of the matrimony, irrespective of whether the marriage is a sacrament or a contract. By no stretch of imagination can it be said that a person consents to harm or violence by marriage, neither does the law permits any person to give such a consent. Marital unity generally talks about the non-existence of women as soon as she gets married. It means that after marriage, the wife's identity merges with the of that of the husband, and she does not have a life of her own. This is called the marital unity doctrine. This doctrine is not applicable in the present day as both men and women have their own individual identities. This, despite the contradiction as incriminating as 2017 Gujarat High Court ruling in Nimeshbhai Bhartibai Desai's state of Gujarat clearly says it has long been time to jettiston the notion of implied consent of marriage. The law must uphold the bodily autonomy of all the women, irrespective of their marital status. Moving on, if women will misuse any law against marital law. In an affidavit submitted by the Delhi High Court to the Delhi High Court, the Union government said a law criminalizing marital rape can be an easy tool to harassing their husbands, absurdly arguing if all sexual activities between a husband and his own wife qualify to be marital rape, then the judgment whether it is marital rape or not will singularly rest with the wife as it should. This argument that women will falsely accuse their husbands left, right, and center has been used for time immemorial and will be used. It was also used during for various other various domestic violence laws. Women in India, including the Protection of Women from Domestic Violence Act, Dowry Prohibition Act, Section 498 of the IPC, which criminalizes physical and mental cruelty against a woman by her husband or his family. There's never any direct empirical evidence for the misuse of kin except the roll rate of convictions in dowry and cruelty cases. But what we do know is that 4 out of every 5 women in India are victims of physical, sexual, or emotional domestic violence. So then the number of convictions as a parameter to gauge the reality of the situation is also problematic because low conviction rates in India are often because of the poor investigation, improper conduct, or no evidence and omission of witness statements, and not because of women do not are out to get men. As regards of women facing malicious charges, it may be noted that if proving a claim of rape in marriage is hard, proving a fabricated claim will be even more harder. Because of the association stigma of rape trials, it is unlikely that women will elect to undergo such an experience of sheer spite and will mostly be ashamed because the questions that are asked in a trial are very brutal and arrogant. Besides, the criminal justice system provides inherent safeguards such as requirement of proof beyond any reasonable doubt. This is no justification to say that victim should be denied protection simply because someone might be at risk of fabricated case, and even if some women misuses the law, that's what the judiciary is there for, to weed out the false cases and dismiss them with an appropriate penalty. The cultural argument and criminalization marital rape won't work in India because women are illiterate, uneducated, and poor, and which directly contradicts the argument that criminalization of marital rape would lead to misuse. If women are not educated enough to properly use the law, it follows that they would be just as unable to misuse the law. Moving on to the next accusation or argument, can the state really enter the realm of home? The answer to this is yes, it already does. In the case of cruelty, divorce, dowry, women demands, then why leave the most atrocious and heinous crime outside the ambit of a state and the laws? Why must the area of marital rape remain beyond its pale? The state, which does not involve itself at the time of marriage but acts as an arbitrator during the divorce, must protect a woman's right to her own body. Thus, the idea of non-interference of judiciary in marital relationships is also a myth rooted in patriarchy and misogyny that the courts use with pride to shield themselves for taking a stand on marital rape. Moving on, no need of legislative need as it is uncommon. Marital rape is a common but underreported crime. A study conducted by the Joint Women Program and NGO found that 1 out of 7 married women had been raped by their own husbands at least once. They frequently do not report these crimes because the law does not support them. Only if it were that uncommon, then the recognition of the civil remedy provided in the Protection of Women from Domestic Violence Act 2005 would not have happened. The next in the argument is impossibility of proving to the charges of marital rape. The near impossibility of proving marital rape, its criminalization would not only serve as an increased burden to the already overburdened legal system, it may be shown that criminalization of marital rape serves to recognize uh, rape in marriage as a criminal offense and would be deterrent effect on prospective rapist husbands. The mere fact that marital rape would be very difficult to prove is no reason for not recognizing it as a crime. On the other hand, there are a set of so many other crimes in the Indian penal code which are really difficult to prove but are still a crime. Moving on will destroy the sanctity of the marriage. Finally, a marriage in which a husband rapes his wife is already destroyed. Attempt to hold together marriages may be one of the objectives of matrimonial laws, but it cannot override the fundamental objective of law in general and that of a criminal law in particular, which is to protect and preserve the bodily integrity of a human being. Thus, withholding justice and denying equal protection for preserving marriages at best can be improper goal of the law. The law should not be encourage forced cohabitation and should not protect a rapist husband. Moving on, there are a lot of international laws on marital rape. The Supreme Court of Nepal struck down the marital rape exception through the case of FWL Gain versus HMG. Also, further in case of Jit Kumar versus government of Nepal, all the other countries, Australia, European Court of Human Rights, United Kingdom, New Zealand, Mexico, South Africa have all criminalized marital rape. Moving on. I'd like to conclude by saying that humanity stands on two pillars, men and women. They should have equal importance and role in its development and growth. But women always have been subject to a lot of humiliation by men. It is an apt example of the atrocities committed against the dignity of women. Even as we celebrate more than 7 years of independence, the women in our country are still not fully free, and independent and will never be independent, continue to live under the realm of darkness and fear. It is indeed a somber reality of India. In India, marital rape exists de facto but not de jure. While in other countries, either the legislature has criminalized marital rape or the judiciary has played an active role in recognizing it as an offense in India. However, the judiciary seems to be operating at cross purposes. No law in its ultimate effect should end up perpetuating the oppression of women. Personal freedom is a fundamental tenet which cannot be compromised in the name of expediency, and thus marital rape should definitely be criminalized. The state's failure to recognize and condemn marital rape would be considered as its complicit acceptance for the same. I'd also like to propose a few suggestions. Recommendations shall also be sent to the Parliament calling for the impugned provisions to be removed and the law be amended in consonance with the constitutionality and treaty obligations. It should be recognized as an offense under the IPC along with the suitable punishments. The wife should have an option of getting a decree of divorce if the charge of marital rape is provided against the husband. Also, apart from judicial awakening, general awareness of such offense by the citizens is also important. Thank you.